Oh, good afternoon or good morning. It looks like I'm having some difficulties with my camera for a moment here. Let's see about fixing that. Let's try that again now. Maybe that's fixed things. Hi there, we are back. Good afternoon or good morning if you're joining us from BCL, Alberta. Sorry for the technical difficulties there. It's something with I have my own personal webcam that I use for these, and I'm using the laptop camera, which is a little bit more grainy, as folks who have probably tuned in to see me before can notice. But if not, then you won't notice anything perhaps different. So thanks everybody for tuning in this afternoon. I'm Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are, of course, the employment lawyers answering your questions here on our typical 30-minute Q&A sessions. Looking forward to another great session as always this afternoon. So just kind of get the ball rolling while we wait for some comments and such to roll in. Looking, of course, at what's going on in the employment kind of law news of late. Piers Bell, from what I have heard, is unfortunately terminating a bunch more employees. I get a number of Bell clients and dealt with Bell many times in the past, and apparently they're terminating approximately 700 additional positions, unfortunately, just prior to the holiday season here, which is, of course, very difficult for the folks who are affected by this, because of course the holiday season is the worst possible time really to be terminated from your job. Emotionally, it's the most draining and stressful, but then also, of course, in terms of finding another comparable job, there really cannot be one worse time than exactly the holiday season for finding comparable employment. So realistically, no employer is going to hire anybody at this point until probably sometime in January or February of 2026. So that's what I've heard come off the news real late. So if you're a Bell employee affected by a termination recently, absolutely feel free to reach out to our firm here, and myself, and happy to look over your package and assess it and provide the accurate legal assessment of what your severance package ought to be, because typically in my experience with Bell, the first offer is typically not the best offer in the circumstances. So certainly reach out to us if you've been affected by those terminations. Bell's been terminating a number of employees lately, especially at the beginning of the year, and apparently now another round of unfortunately terminations, especially I've seen many very long service employees, some with 30, 40 years of service, be affected by these terminations. So absolutely reach out to us here at Samfiru Tumarkin to get a accurate and full legal assessment of your severance package from Bell to ensure that it is adequate in the circumstances. Because typically, again, in my experience, those packages are not adequate in the circumstances. So absolutely reach out to us. The primary issue, of course, in terms of assessing a severance package, it needs to adequately provide for, number one, your years of service, number two, your age, and then typically number three, the nature of your position. And of course, a maximum severance package is typically on the order of 24 months of notice or pay in lieu of notice. So basically, severance in effect. Those payments obviously very substantial and significant, especially for folks who've been employed for 30 plus years. No question is your legal entitlement to a severance package. Probably always 24 months in the circumstances. So absolutely feel free to reach out to us if you've been unfortunately affected by these Bell terminations of late. Just waiting for some more questions to populate in the chat here before we jump right into it. But again, if you're just joining us, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thanks very much, everybody, for tuning in again this afternoon. So while we just wait for a few more questions to populate here, we'll just talk about a number of comments and such that are occurring, of course, generally in employment law, stories and things that are happening. So for instance, one question we receive often is about remote work and employers, switching from folks who have been employed, only remotely to now wanting them to come back into the office and to do their job on a hybrid basis. And the unfortunate, reality for that is that because it puts a person in a very difficult spot, especially if they've been working, remotely for perhaps 3, 4, 5, plus years. And if that is the case, that you've been working for that long remotely, and now the employer wants you to come into the office, even on a hybrid basis, that may well be a constructive termination of your employment and a breach of your contract, which is the same thing. Ultimately, in the day, what it means is that you may be owed a severance package by your former employer because they have changed the terms of your employment to require you to attend work, by either a hybrid basis or entirely or solely, in person, one or the other. Again, ultimately, that means that you may be entitled to a severance package, especially again if you've been working remotely, for probably 5+ years. From what a legal perspective would say there is that, regardless of what exactly may be in your contract of employment, if you have 5+ years of working, solely entirely remotely with a particular employer, that term has basically become, for all intents and purposes, a part of your contract of employment, that you must be allowed to work remotely. That is now part of your contract. And so again, if the employer is trying to now change that term, it may well be constructive termination of your employment. So that's happening more and more frequently of late, as we see employers shifting folks who have been working remotely for several years back into the office. Again, don't simply just accept it for what it is. Absolutely reach out to us here at Tumarkin and get a legal assessment of your situation, circumstances, because you may well be owed a severance package from your employer because they have in fact terminated your employment by requiring you to come into the office, even on a hybrid basis potentially. So if somebody's affected by that, absolutely reach out to us. Here we have folks standing by all the time to answer questions and get a legal assessment provided of your particular matter. So now I see some bunch of other questions are popping into the chat, which is fantastic. So I'll jump to those right now. So it looks like Laura from YouTube has asked, if a company is selling their plant slash property assets, but keeping their business, and the employees might be offered new employment from the takeover organization, what employment laws apply? That's a great question, Laura. So there's kind of two ways that this can occur. One, and the most common way, is, I think this maybe is alluded to your question, the company is being acquired by another employer. Basically, the ownership interest of the company is being acquired. And this actually sounds a little bit different. So yours actually probably falls into the second category, and we'll get to that in a second. But the first category, the most simple one, is simply you're going on along in your job, and then one day your employer is bought out by another company. Okay, so you've been acquired. Nothing changes for you as an employee. You just simply kept on working as you did every single day. So in those circumstances, your employment is inherited by the new employer, and that's the most common thing that occurs. So whatever your prior service, you had 5 years with the previous employer before it was acquired. Well, then the new employer has now inherited that 5 years of service. So your service does not change, and your legal entitlements do not change in that circumstance. The second possible outcome of this scenario that you mentioned here is, I think, what you're talking about, that potentially your employer is on the verge of kind of bankruptcy or something along those lines, and is selling off their assets and properties to another company, and the company is only purchasing those assets. Basically, they're not purchasing the business as what's called a going concern. Instead, they're just purchasing whatever the tools are, the computers, the office space, whatever perhaps it may be. It's purchasing those things. So that's a different set of circumstances. If that is the case, then, as you mentioned here, you've been offered another employment contract. So basically you have two options. If that is a comparable employment arrangement that the new employer has offered you, then you perhaps will consider accepting that job and going on with a new company. If, however, the new company does not offer you a new job that's comparable in terms of what you previously had with the original employer, then you've been terminated, and the current employer that still exists must pay you a severance package. So the very key important distinction here, Laura, as you've indicated, is that your employment will not just continue carrying on as it was prior to everything happening, prior to your employer being acquired, for instance. There's a clear break. You have now a choice to make. Either you take another job on, again, hopefully it's comparable terms with a new company, and in those circumstances, again, typically, unless there's very clear language in the agreement that says otherwise, your services would also be inherited as well. Or again, you reject that offer because it's not a comparable job for whatever particular reason. And again, your current employer, who's selling off all the business and assets, owes you a severance package in the circumstances. That's typically the two scenarios that we see. And so, Laura, the most clear and simple thing I can say in this particular matter is that you certainly probably want to reach out to us here at the firm, and you certainly can go on our employmentlawyer.ca website. There's a severance calculator there as well, of course, that you can use to determine the extent of your legal entitlements. Just hypothetically, how much could you potentially be owed based on your age, your years of service, position, so on and so forth. That will kind of give you a general figure for that. But in terms of this whole situation and looking at a new contract versus your old contract, perhaps the case that you didn't even have a contract with the last employer. It was just a verbal contract effectively. So now the employer wants you to sign a written contract, which may have very restrictive provisions trying to limit you to the SA minimums, which are the minimums under the Employment Standards Act, so that you don't get a common law severance package, which can be up to 2 years of severance upon your termination. So what I'm saying here basically, Laura, is that you should probably reach out to us here at the firm and have us go over in more detail and specificity and thoroughness the nature of these two. What was your previous contract situation? What's the new contract? Is it actually comparable? If it is comparable, and everything's considered there, do you want to take that job and go forward with that? Or, because there's lots of reasons that go into this, is it not a comparable job? And if that's the case, then you probably want to pursue your current employer here for a severance package and find another job elsewhere that is comparable to what you previously had with your original employer before basically it went on the verge of bankruptcy. So that's unfortunately the most simple and plain answer that I can give, Laura. Yours is unfortunately the second, the more complicated of the two scenarios, and it really requires, again, a legal assessment and insight in terms of what is the nature of your contract and what is the new employer trying to get you to agree to, because there's a whole bunch of different things that can make this new job extraordinarily less favorable than your current job, especially if it's the case that you've been at the current job for 10 plus years, for instance, and now the employer is trying to limit you to only the SA minimums, which can be a matter of weeks rather than months of notice. So to be simple about it, I would definitely recommend on this one you reach out to us. We have folks standing by and have an assessment of your situation here. In the circumstances, but I appreciate the question, Laura. It's a great question and very, very helpful. Most folks will not find themselves in the position that unfortunately Laura finds herself in. Most folks, it will simply just be the company's acquired and you continue on working like nothing ever happened, and the new employers just inherited your service as is required by the law. And so if you're ever terminated by that new employer, then it's simply the case that they owe you a severance package based on your total service with both organizations. So, but I appreciate the question, Laura. It's a really good and useful one because it comes up, this situation comes up very often. Companies are often trading hands this way and that way. And it's very, very important to know, what your legal, what happens to your legal rights, what happens to your length of service and things like that when your employer is acquired or purchased in an asset purchase as yours is in the circumstances. So moving right along here, I see a bunch of other questions coming up, which is fantastic. Looks like Karen from YouTube has asked, my father was just let go from his job. He's 67 and was planning to work another 2 years or so. They are saying they are retiring him. Can they do that? So sort of the answer here, Karen, absolutely not. No, they cannot force your father to retire. That's simply not possible. That needs to be his choice to make. If he's being, if they want him to leave the company, then they must terminate his employment and they must pay him a severance package at 67 years of age. I'm not sure what the other factors of his employment are, but probably that's going to lead it, to the conclusion that he would be owed, a significantly greater package than someone, for instance, who is 30 years of age or 40 years of age. Age is a critical key factor in assessing how much severance one is entitled to under common law. So, short answer, absolutely not. Nobody can be forced to retire. He must make that decision himself. It doesn't sound like he wants to make that decision. It sounds like he wants to keep working. So in that case, then one of two things are happening here. Either they're going to constructively terminate his employment, or they will terminate his employment. And in either circumstance, he's owed a severance package from this company, almost certainly. Of course, we need to assess if there's an employment agreement, things like that, but absolutely reach out to us. Again, the pop-up list come up there, employmentlawyer.ca. You can, of course, also use our severance calculator to have a further kind of look at, just generally speaking, what could your father's legal entitlements be under common law, based again on his age, years of service, position, rate of pay, and so on and so forth. Entirely anonymous there, but on this one, certainly reach out to us. We have folks standing by to get a legal assessment of this scenario and situation. And for the moment here, again, you can go back and tell these folks, no, he's not retiring. He wants to continue working. And again, so they can, either the option is that he was allowed to continue working, or they terminate his employment. If they want to do that, they got to pay him a severance package. Certainly reach out to us about that. If the employer's response is not favorable. But I appreciate the question, Karen. It's a great question. Again, nobody can be forced to retire. You must do that voluntarily yourself. And of course, folks who do retire are not entitled to a severance package, which is very critical here and key, and probably why the employer wants him to retire, because of course then they get off the hook of paying him perhaps quite a bit of money, especially at 60, 70 years old. So absolutely reach out to us about that. One final comment I'll just make on that point is it can also potentially be an issue with potential discrimination and under the Human Rights Code there. Based on his age, they want him to basically retire and leave. They cannot do that, obviously, under the Human Rights Code. Age is protected ground, and so there may be also a human rights component and damages owing from that as well. So certainly, if these folks don't respond favorably to, no, I'm not retiring as a response, absolutely reach out to us. Happy to look at that further in the circumstances. So moving right along here, bunch of other questions have come in, which is fantastic. Looks like Tini from YouTube has asked, I worked for an employer for about 3 years now. One of the stores recently transferred me to a new location a few months ago, different company name. There's a bunch of different ones here. Now I found a few days ago that he's been keeping some of my tips for a few weeks. It wasn't like this the first location store. He said since it's a different store, it's different. And I've told him I never would have switched if I wouldn't get my full tips as allowed. So no, of course, the employer can't withhold, your tips, if that is a part of your contract of employment. Either, it's an express term of your contract that you obtain, tips basically, or it was an implied term of the contract, meaning a verbal term, because you worked for 5+ years and you've always received tips, and one day this gentleman comes to you and says, hey, can you switch stores? And you say, oh yeah, sure, that's fine, and then he tries to change the terms on you. That's again would be a constructive termination potentially there of your employment, number one. Of course, in this circumstance, if it's just the tips that are the issue, perhaps your initial recourse may be, again, depends on what your tips are. If your tips are 20% of your income annually, again, that may well be constructive termination. You should certainly reach out to us to get a further legal assessment of that. If the tips are a lot less than that, 5%, maybe 10% of your wages at best, annually, then maybe something you wish to look through, go through the Ministry of Labor for. They can assist with things, issues about wages. Short answer is no. The employer cannot just assert that no longer you're going to be receiving tips because something is different with this other store and company. Again, I don't know what employment agreement you may have signed or not have signed, but in the circumstances that could be a factor here. It doesn't sound like it is a factor. It sounds like he just told you, hey, you want to transfer, you want to go over, but you said, oh, sure, fine. And then again, this kind of comes out of the blue here. So I would suggest look at how much are your tips in terms of versus annual rate of compensation. Are they 10% of your compensation, 30% of your annual compensation? Again, if it's 15% plus of compensation annually, and that you're no longer getting that amount of money, may well be a constructive termination. You're owed severance entitlements there, so you should reach out to us in that respect. Again, if it's a lot less money, under 10% in terms of annual earnings, basically, in terms of how much the tips, component equates to. That would probably be more of a Ministry of Labor, avenue that you may want to look into there. Either way, based on what I'm, initially hearing here, I don't think that your employer can do this. It doesn't seem legal to me, and so you have recourse, either to a lawyer like myself, or to the Ministry of Labor. Again, if it's a smaller amount of money in the circumstances. So I appreciate the question. It's a great question because, again, employers, often kind of do these things where they try to, impose different, terms and conditions of employment that, substantially change what your legal entitlements, are in terms of, what your annual rate of pay is, perhaps your hours of work, which affects your annual rate of pay. And the fact is, they cannot do that. The employer does not have the absolute discretion to do that, if it's a material and significant change to the terms of your employment, i.e., other words, 15, 20% plus, reduction in your wages absolutely can never happen. That's a constructive termination of employment. You're owed a severance package, in the circumstances. So definitely reach out if that's, any kind of situation that you are confronting in that respect. So we have a few minutes left here. Then move on to the next few questions. Looks like Reggie from YouTube has asked, can your employer refuse to give you a cost of living wage increase? So the employer potentially, can have discretion there, Reggie, if it's, small salary increases of, 2% to 5%. The employer's business may have some particular issue. You're not, unfortunately, legally entitled to, raises, salary increases on an annual basis. The issue, becomes ultimately, how much are the annual, increases that you're potentially owed? Is there a history of them that exists prior to? Usually these are not, salary increases are typically in the range of about 2% or so, maybe 2 to 5% to keep up with inflation. Those circumstances, again, unfortunately, there's nothing that legally requires the employer to provide that to you. That's really their discretion to provide it or not. If the raises are much, much more than that, 10+%, again, of your annual wages every year, and they are now refusing to provide that, that's a whole separate scenario, and that may be a constructive termination of employment in the circumstances, and payment of a severance package flowing from that. But again, it sounds like, unless you want to share further details, I'm assuming this is an inflationary increase, so 2 to 5%. In those circumstances, again, employer's discretion. Unfortunately, nothing legally requiring them to do that, unless it's expressly in your contract of employment that the employer has said, every year we will provide you with this, cost of living raise, basically. Or alternatively, it's not expressly written in an employment contract. Instead, you have a 10-year history of receiving these every single year. That could be potentially an issue there. But again, if it's 2 to 5% of your annual earnings, it's probably not getting it high enough to demonstrate a constructive dismissal. So unfortunately, in your circumstance, I don't think you may have much in terms of legal recourse. But again, if it's a lot more money, 10% plus of your annual pay, then that's a big different. That's of course a much different story. That may well be constructive termination and payment of severance package. A few questions here. We started a little bit late, so let's go for a couple more minutes. Looks like Amanda from Facebook has asked, is 3 months probation upon hire automatic in Alberta, or is there a contract/agreement that has to be signed to agree to this? So I'm based in Ontario, Amanda. I have some general understanding of the employment situation in the Alberta Employment Standards Code. My general understanding is that there is a provision in that code that speaks to probationary period for employees, so it doesn't need to be written into the contract. That being said, the caveat there is, and I get lots of these cases, I have many of them, where perhaps somebody is terminated within the probationary period. It does not mean that you are not owed potentially a severance package. all it means is that the employer, maybe to limit you to whatever the minimums are under the legislation. Typically, the minimum for less than 3 months is no payment or severance whatsoever. But again, it doesn't mean that at common law you may not be entitled to a severance package of a couple months or a few months or something along those lines. That depends again on your contract, whether the contract has provisions in it that are enforceable or not. And what I do primarily as an employment lawyer is defeating contracts, defeating the termination provisions, demonstrating that they're illegal and unenforceable, and thereby getting my client access to a severance package of common law. So to answer your question again very simply, if you've been terminated here in the probationary period, yes, you may be limited to nothing under the legislation, but you may still be entitled potentially to entitlements under common law. And so you should certainly reach out to us. You can see our links just popped up there in the bottom, employmentlawyer.ca. And perhaps, again, you may be entitled to a severance package here if we can defeat and determine that the provisions in your contract are illegal, non-enforceable, and therefore you're owed a severance package at common law in the circumstances. So definitely reach out to us about that, Amanda. I get these cases all the time. If you're in a union, that's different. That's a whole different can of worms. We only deal with non-unionized employees. If you're unionized, everything is governed by the collective agreement. You have to go through your union approved, legal counsel, which means, approaching a union rep, they will deal with it, and their legal counsel will deal with it. Unfortunately, in unionized workplaces, and if you're a unionized person, you can't have a private employment lawyer like myself, unfortunately, deal with these circumstances. It's just unfortunately how the law works with respect to unions. All your entitlements are governed by the collective agreement. So jumping on here, once get back to, I think Laura has asked a follow-up question from YouTube. What happens to employees terminated due to insolvency or bankruptcy? Can termination or severance pay still be received in some way? So unfortunately, Laura, in those circumstances, except, and I'm assuming you're in Ontario here, there's a very small amount of money potentially you can get under what's called the Wage Earners Protection Program, which I think is a maximum of $2,000 if your employer you're terminated due to insolvency / bankruptcy. If that is the case, the employer is insolvent or bankrupt. The unfortunate reality is that there's no way to pursue them civilly to get a severance package. That bankruptcy a filing of that nature stops any kind of legal proceeding or process against the company. And then it's, perhaps if you do ever obtain anything one day, it's pennies on the dollar. Once again, the employer has paid off, all their other, secured creditors. You're an unsecured creditor, basically at the very bottom of the list. And again, it's pennies on the dollar at best, if anything, unfortunately. It's very, very, the law in that respect is very, very preferential and bent towards the interest of the employer and with respect to bankruptcy and insolvency. So, yeah, except for the, again, if you're on Ontario, about $2,000 you can get under the Wage Earners Protection Program. You really have no recourse, unfortunately, in a bankruptcy insolvency situation, if that's the case with your employer there. Again, the law shouldn't be that way. We, as part of what we do, we strive to, have the law improved in that respect and amended. But the reality is currently that's just how the law, the state of the law is extraordinarily, favorable to the employer there. Anyone who claims bankruptcy or insolvency, they're basically getting off scot-free in effect. That's the unfortunate reality of how our government and legislation operates here in Ontario and generally in Canada. So thanks everybody for the great questions this afternoon. Thanks for bearing with me with the initial technical difficulties. Again, thanks everybody for tuning in. If you enjoy what we do here, please like and subscribe if you're on any of the platforms, YouTube or Facebook or whatever it is. And of course, we will have another regular installment. Looks like, of course, my managing partner, Lior Samfiru, will be with you folks on December the 3rd, tomorrow at 1 o'clock in the afternoon, Eastern Standard Time. So again, thanks very much for tuning in, and hope you have a great rest of your day.